Nigga kill over a bitch, but let a rat keep his life.
Hey y'all, it look like it's ugly for Ynw Melly. Nah, y'all know in 2019, Ynw Melly got locked up for downing, getting that job done on Sack Chaser and Juvie. Y'all know them niggas wasn't right. I'ma tell you right now, I would have done the same thing. You not finna be talking crazy to my girl, my mama, beating up on me, knocking goals out my teeth, stealing money, just doing whatever you want to do because I'm a little nigga. You ain't just about to be doing me like that. And we supposed to be buddies, friends. But this case is going on. I'm finna go ahead and play all this footage of where the prosecutor saying they got footage of this nigga tampering with the witness. Bortland already took his plea deal to it, so that makes the situation even more worse for Melly because tampering with witnesses was already admitted to, and they saying they got it on video. Let's get into this.
You will disagree on this, but the state's position is that the writings that we intend to use, the calls that we intend to use, while it is maybe Terrence Matthis' voice on the call, it is actually the defendant's words. They're his letters. We do have jail video we intend to present where he is, and it's all explicitly stated in the warrant affidavit and PC affidavit, where the defendant is holding what appears to be a kite, which is a letter. It passes jail, goes under his door. Another inmate takes it, passes it through the wall. Another inmate grabs it on the other side of the wall and presents it to Mr. Matthis, who then walks over to the phones and makes a call for Henry. And so that's okay. There. I can provide Your Honor with the calls that we intend to use to make rulings ahead of time, but I do think there are multiple layers to these calls. The first layer, not even being co-conspirator statement, I would say they're not being authentic, not asserted, but it's a statement of legal significance, aka an offer of fact, therefore not hearsay. And then the other statements that would not fall under that hearsay, non-hearsay ruling would be the co-conspirator statements. And I do believe there is sufficient evidence, either just spelled out in the affidavit or the affidavit, to explain that there was a conspiracy going on. Obviously, under the evidence standard, we do have obviously the verbal acts that we do not consider hearsay as part of the conspiracy. We have the James Howard calls to Mr. Henry. We have payments made by Mr. Demons to Mr. Matthis' attorney, George Perez. We have the defendant's phone privileges revoked. We have texts between Mariah Hamilton and Geneva Molina. We have other calls Mr. Matthis made to Portland Henry about Mrs. Barnett. We have Ms. Hamilton not showing up for trial or deposition. And we have that jail video.
So I'm gonna take it as y'all heard what I heard. They got Melly slide notes and everything else. If they got him on a jail video doing this, tampering with witness or evidence, or you know what I mean. Y'all know that hold up to life. And this is a different case other than the murder trial. This ain't the same thing. These are two different things. Messing with the witness, tampering with witness, then you got the murder. If he get convicted of just tampering with the evidence or the witness, that could put him away. And like I said earlier, you got Cortland, who already took a plea to it. Him taking a plea deal to it definitely put Melly in a bad situation because that's an admission of guilt. But now I'm wondering, did he sign a paper to testify against Melly in this case? So if he takes this to trial and don't take no plea to this, which they didn't give him a plea, I'm looking at it like if he convicted, they going the whole way. They're not going to give him the bottom end of a sentence. They're going to give him the top, which is life. But let's see if the defense and the lawyer got some fight in them. This where she get her money at. she better do something. Let's get into this.
Mentioning appears also to be hearsay. I'm not sure what statements of legal significance mean in terms of the exception to hearsay rule or operative facts, but it does seem like it is pointing an issue we're going to have to address as we see how the evidence comes in. I would remind the court that the dates alleged are April 10th through July 22nd, 2023. And the state has been very cooperative with providing discovery, so I'm sure we're going to get this information. The videos we have at this point appear to all have occurred after the dates charged in information, but that might just be how they came across. So we'll have a chance to look that up and see if there are any. So I know from the court order that we have to have exhibits.
Well, just so you all see it.
Yes.
You don't have to turn them into me.
I know, but that would give us a chance.
Yeah. Okay. All right. So I'm picking up number 5. Hearsay statements contained in the writings and phone calls of Terrence Matthis. I'll defer on that one, and I'll give you a ruling at whatever time it arises during the trial, based on whatever objection either side thinks they need to make. So.
Judge Finlay, I'm sorry, the majority of paragraph 5, and what we've argued about, is a lot of statements. So we would really need a ruling prior to the jury being sworn, because obviously that would affect whether or not we go forward. So if I may, maybe we can put together some calls for your honor to listen to, and we can have a hearing paper argued prior to the jury being sworn.
I mean, if you want to turn something over to me and have me reviewed ahead of time, as long as they have it and they don't object to it, I'm happy to do that. I've never heard any of these calls. I've never seen any of these writings, so this is all in a vacuum for me.
And just so, the argument really is the conspiracy has to be proven, not through the hearsay. So having the phone calls aren't going to necessarily give the court the information needed to determine whether there's independent evidence of the conspiracy so as to allow the phone calls that are hearsay. So I think that almost requires an evidentiary hearing.
The state's arguing that some of these calls, the statements within the calls, are not hearsay.
Yeah, listen, I'm not quite sure how I can do that before the trial, but I mean, I'll try to craft some time for you, and this isn't something you want to do tomorrow.
I would have to get all the calls together and but I can try.
Okay. Well, as to that one, I'm going to defer on it when we get done with our discussion today. If you want me to schedule something in the future, understanding that I'm starting, as I'm sure you all know, I'm starting another capital case on Wednesday, so I might have a limited amount of time, but I'll do the best I can for you. On my case on Wednesday?
I might be able to.
Well, I think I'm going to decline that invitation at this point.
No, it's scheduling purposes, but it's not anything with the actual case.
Okay, well, press pause on that. Number 6, the resolution of Cortland Henry's case and the resolution of Terrence Mathis's case. Yes, ma'am. All right, you're not going to introduce any of this.
Correct.
All right, so that one's granted. We're not talking about how they resolve their cases.